Good evening, ladies and gentlemen, my lords, ladies and gentlemen. Delighted to welcome you to Gresham College. My name is Sutherland. I'm the Provost of the College. I think because of our well-established link that leads to this evening's event, many of you will know a great deal about the College. But perhaps the best way to have a quick tutorial is simply to look at some of these books that represent something of the history of the College and some of the great figures who have been, over the years, part of this college, including most recently a celebratory volume on Robert Hooke. We're very proud of our history, but we're also very proud of our link with Gray's Inn. And the link is not specifically initially college to Gray's Inn, but buildings. And Barnard's Inn was, I think, dear to the hearts of those in Gray's Inn, as in our near neighbour Staple Inn. And as a result of that, of course, the tradition has grown up of having a Gray's Inn reading here. And happily, it coincides quite normally with good weather, and we hope that continues, and there'll be a reception outside in the courtyard, all being well. Our speaker tonight, Lord Justice Richards, my brief tells me when he was born, but I don't think I'll enter into that. He was called to the bar at Gray's Inn in 1975, standing counsel to the Director General of Fair Trading in the late 80s, junior counsel to Crown Common Law in the early 90s, first junior Treasury Counsel, Common Law 1992 to 97, moving up through the ranks of the system, Recorder, then High Court Judge at the Queen's Bench Division, presiding judge in Wales and Chester Circuit. That must have been nice. I mean, if you're going to be a presiding judge on circuit, find somewhere with a decent countryside round about it. And of course now, Lord Justice of Appeal since 2005. We're privileged to invite you here to have someone of such distinction to give the lecture this evening. And I'm happy to announce the title as The International Dimension of Judicial Review. I welcome you to the College.
Thank you very much. If judicial review has penetrated the popular consciousness at all, I suspect that the government minister most closely associated with it is the Home Secretary, because whether the hot topic is the detention of suspected terrorists or the removal of failed asylum seekers or of released foreign prisoners, it is the Home Secretary who seems constantly to be in the frame. I wouldn't be surprised if his department were at the receiving end of more judicial review claims than all other government departments combined. But the point is better illustrated by reference to television than to court statistics. Regular viewers of Judge John Deed will be well aware that it is the fictional Home Secretary who is repeatedly on the receiving end of embarrassing litigation and who resorts in consequence to flagrant but happily unsuccessful attempts to manipulate the judicial process and to promote the interests of the government over those of the individual. For today's lecture, I have chosen a topic that takes the spotlight off the Home Secretary and moves us away from home affairs into foreign affairs and military conflict. What I have to say falls primarily within the provinces of the Foreign Secretary and the Secretary of State for Defence. 20 years ago, this was an area on which there was very little to say. In recent times, however, our courts have been called upon to grapple increasingly with problems arising outside the United Kingdom and with the effect of international treaties and principles of international law. What I have to say on the subject is intended for a general audience, despite the fact that I see a few specialists within the audience. It comprises a survey of cases which are interesting for their factual background as well as for the legal analysis to which they give rise. I'm afraid there's not a lot of humour in it, but these are very serious topics. Matters such as the conduct of foreign affairs and the armed forces are traditionally and very properly areas in relation to which the courts exercise great judicial restraint. The position used to be very simple indeed. The powers of the executive in such areas are generally what are described as prerogative powers. they're best thought of as the common law or non-statutory powers of the government, as distinct from powers derived from parliamentary enactments. It was long considered that whereas there could be judicial control over the exercise of statutory powers, prerogative powers were beyond the scope of judicial review. Happily, that view made its end in a case in 1984, arising out of a battle between the government and the civil service unions over a decision to change the terms and conditions of staff at GCHQ without consultation. It's the Council of Civil Service Unions and the Minister for the Civil Service. In that case, the House of Lords held that it is not the source, but the subject matter of a power that determines whether it is susceptible to review. So the fact that a minister is exercising a prerogative power rather than a statutory power is not in itself a decisive factor. Whether the courts can control the exercise of the power depends instead on the particular subject matter. That principle is of great importance, as we shall see. But their lordships also made clear in their judgments that among the powers considered not to be susceptible to judicial review by reason of their subject matter were powers such as those relating to the conduct of foreign affairs, the making of treaties, or the defence of the realm. Areas of high policy of that kind were considered to be non-justiciable. At much the same time, in litigation between British Airways and Laker Airways, arising out of the collapse of Laker's transatlantic SkyTrain operation, the Master of the Rolls said that the foreign policy adopted by Her Majesty acting on the advice of her government is in reality that of the nation, and that accordingly it would be strange if in this field the courts and the executive spoke with different voices, and they should not do so. In the same judgment, he made observations about the effect of international treaties. He said that as a matter of English law, a treaty is an agreement between sovereign states, which does not of itself give rise to rights or obligations between individuals. And consistently with this approach, the court has no jurisdiction to determine the meaning or effect of a treaty to which the government of the United Kingdom is a party, and indeed the court is not equipped to do so, that being a matter of public international law. Well, that principle has long been subject to a number of exceptions, but as a more general point, it has become clear from recent cases that the courts no longer have the same inhibitions about addressing public international law. Similarly, recent cases show that the forbidden areas of foreign policy and the like are much narrower than might have been thought, and that the CCSU case, the Civil Service Unions case, has opened up very considerable scope for judicial review in these fields.